Well, hello and welcome to you all. Thank you very much for joining us today on our final talk in our cargo claims series, our third series. Many of you will already have seen our time charters and voyage charter series. And here we are focusing on a practical guide to cargo claims. You will see very little, if any, reference to case law or citations in this talk. It is very much based on our experience of how, in a practical and in some senses human sense, to handle and conclude cargo claims efficiently. Now, before we get on to the talk itself, it will last 45 to 50 minutes. There will be some questions afterwards. It's being recorded, and you should have received via email some of the handouts that we will be referring to in the context of letters of undertaking. And if you haven't, then they are also available via the chat function in the control panel, which should be to the side of your screen. And at the same time, please do submit any questions that arise as we go along via the Q&A function, which Sarah and I will endeavour to answer at the end. And we've already received some questions for which thank you, and we will address those in the first instance. So, just before we get started on the talk itself, a brief introduction to your speakers. Sarah and I are both partners in the shipping team here at Burkitt's. I'm almost hesitant to say that between us we have nearly 40 years' experience of handling cargo claims on an almost daily basis. So I hope you feel that you are in good hands in that respect. And we form part of a much wider firm. Burkitt's, as a firm, it's a top 50 firm with over 1,000 people. And when Sarah and I joined many moons ago, we were a mere 250. And one of the reasons that the firm has grown so much is due to specialisms such as shipping. And there's a rogues gallery of the shipping team. We are 20 or so lawyers specialising purely in wet and dry shipping, international trade and transport, and marine insurance. So this is absolutely our bread and butter. And you'll see on the screen there some of the very nice feedback that we have achieved over the years. So onto the talk itself. As I say, it's a very practical talk, and it's comprised of 5 different elements. The first is a checklist that's both relevant for, and in fact, all of this talk, I should say, is relevant for both sides of the fence, both for carriers and club claims handlers, and also those in insurance companies or recovery agents, etc., handling claims on behalf of cargo interests. We are agnostic in this sense during this talk. But we have, to start with, a checklist on the things to consider in every single cargo claim. Then we look at the very important issue of security. Then onto the practical conundrum that can be mitigation and quantum, before moving on to our thoughts on negotiating strategies, and then finally a brief word on circular claims, which is something that is very easily overlooked. So, Sarah, over to you.
Thank you very much, Henry. So we thought we'd start this webinar with a cargo claim checklist. Now, I appreciate that this is quite a full slide, but this is deliberately so. The idea is that this slide can be your cheat sheet for all future cargo claims. If you follow the steps on this slide at the start of every claim, whether on the carrier or the cargo side, you should be off to a good start. Now, taking each of these points in turn. The first question to consider is the claim potentially enforceable? As a cargo interest, little is to be gained from pursuing a claim that can never be enforced. So the questions you need to be asking are, can security be obtained via an arrest? Does the carrier have other vessels or assets that can be attached in a favourable jurisdiction? As a cargo interest, these are all questions that should be considered at the very outset of a claim, particularly if a carrier is likely to divest itself of assets in the near future. Henry will talk to you further about this in a moment. The second question is, what is the relevant contract of carriage? Now, generally speaking, this will be the bill of lading, but be careful. If the parties to the bill of lading and the charter party match, i.e. they are identical, the relevant contract of carriage is the charter party, the bill of lading becoming a mere receipt. The third question is, which law applies? Now, this might sound a straightforward and obvious question, but you'd be amazed at how often mistakes are made. In particular, be careful with liner bills in which the law and jurisdiction may differ depending on the load port, i.e. English law, except if the cargo is loaded or discharged in the US, in which case US law and New York jurisdiction may apply. The fifth question is, who has title to sue? Now, I cannot stress enough that this is absolutely critical to ensure that this is correct, and that's regardless of whether you're on for cargo or for the carrier. If the relevant contract of carriage is a straight bill, then this is likely to be a relatively straightforward exercise. If the bill is a bearer or a to-order bill, then determining who has title can be a much more complex and time-consuming exercise, which may require detailed interrogation of endorsements and underlying sale contracts. It's really worth spending time on this at the outset, as a claim in which an attempt has been made to protect the claim in the name of the wrong party will be time-barred. And if you want more detail on that point, I suggest you look at our webinar on the bill of lading as a contract. Now, the next question, question 5 on the list, is who is the carrier? Now, often this is a more straightforward question, but not always. This is again covered in the bill of lading as a contract webinar, but in brief, look at who has signed the bill of lading and be cautious of bareboating demise charters, which can be hard to spot. So you may want to consider pursuing the cargo claim in tort. Now, whilst it's a complex point and probably something that could be the subject of his own webinar, pursuing a cargo claim in tort can be advantageous when a carrier's negligence leads to cargo damage or loss, and the cargo interest doesn't have a direct contractual relationship with the carrier. This approach is particularly relevant when the carrier is a bailee, as tort can establish a duty of care, and the burden then shifts to the carrier to prove it wasn't negligent. The next question on the list is, what are the terms of the contract? And it's really worth spending time on this point at the outset. In particular, what time bars are applicable? These could arise via incorporation of the Hague or Hague-Visby rules, or via a bespoke clause. And we suggest that you make really good calendar notes of these, again, whether you're on for the carrier or cargo. As a cargo interest, there's nothing worse than dropping a claim due to a time bar mistake. Conversely, if you're the carrier, it can be a really satisfying way to kick out a claim, so really make sure you've got those time bars diarised. And aside from time bars, you also should consider the full contract. In particular, does the bill of lading incorporate the terms of a charter party? If so, what are those terms? By way of an example only, if a cargo claim relates to stevedore damage, who is responsible for those stevedores pursuant to the terms of the contract? So that's the bill of lading and any incorporated charter party, including the Hague or Hague-Visby rules. And question 7 on the list is there satisfactory evidence of the condition or quantity of cargo on loading and the same on discharge? And with any cargo claim, this was again discussed in our previous webinars, the initial burden of proof is on the cargo side to show that the cargo is loaded sound and discharged damaged or with a shortage. Now, whichever side of the fence you're on, it is critical to make sure that this evidence exists at the outset. If you're on the cargo side, you will not be able to advance the claim without it, or you're at least very unlikely to be able to. If you're on for the carrier, you're likely to have good grounds to reject the claim if this evidence is missing. And lastly, consider the quantum of the claim, and I'll talk about this further in the third section of this webinar. Now, I'll hand you back over to Henry to talk you through enforcement of claims.
Thank you very much, Sarah. On to enforcement, security. Now, this is as important, effectively, as the merits of the claim itself. If a claim is unenforceable, then however good it is, it's not going to lead to financial compensation for cargo interests. And equally, from a carrier's or club's perspective, if, for example, the claim is against one ship-owning company and that ship has been sold, it's a crucial point for the club or the carrier to be apprised of, to know that there is going to be a real difficulty in securing the claim, and that will inform the approach to take towards settlement more than perhaps any other element. So absolutely critical. And there is a real art to negotiating security and a number of points that have to be taken fully into account. And I've divided this section up into preliminary points and then more detailed elements that we'll look at in a moment. And I'll be looking at the notes or the documents that accompany this section of the talk in the form of a letter of undertaking that is cargo interest favourable. That's the longer LOU, a much shorter carrier/P&I club favourable LOU, much less detail in it. And then thirdly, briefly, a demise side letter, which I will mention in a moment. So those are the documents that we will go to. Right, these preliminary points. The first question is, do we actually need security? Now, if a claim is under a liner bill against Maersk or MSC, for example, they have huge fleets. They have very, very substantial assets. There really isn't any need to get security for the claim because that claim will simply be enforceable. It will not be an issue. But for other instances, it can be absolutely critical. So if it's a claim under, for example, or in relation to the carriage of a bulk cargo and the vessel in question is owned by an entity that has no other assets, cargo interests need security and they need it quickly. Otherwise, if that ship is sold, then with that sale goes most likely all chance of ever enforcing any satisfactory negotiation or award or judgment. And then there's the position relating to fleets where, for example, the owner in question, the carrier, under the bill of lading has a fleet of vessels, so there is the possibility of enforcing or obtaining security against a number of ships, and so there isn't that immediate risk, but nevertheless there can be a real benefit in getting security, A, for comfort, peace of mind, in case all of the fleet is sold in due course, and B, a number of clubs will look at security, look at letters of undertaking as a liability or a contingent liability in their books. And so it is something that they will view as an imperative to deal with the claim more proactively. And so it really can assist in the early resolution of a matter. The next point that I have put on this slide is the imminence and viability of an arrest. Now, that's critical for setting the scene in terms of negotiating power. If you as cargo interests are trying to threaten an arrest in a country where, in frank terms, there is no viable prospect of an arrest, either because the local procedure is too expensive or requires counter-security, or because there just isn't the time, because you need signed, apostilled documents, etc., and it varies enormously from country to country, then the parties have to cut their cloths accordingly. And on the other hand, if, for example, a ship is calling into Antwerp or Rotterdam, Belgium and the Netherlands, where ship arrests can be done very quickly and very easily, there is a real imperative on the part of the carrier and the club to provide security so that the ship is not delayed by arrest. So that practical element, the size of the stick that cargo interests have, really needs to be taken into consideration. And linked to this, there's the question of what form of security is acceptable. In general terms, letters of undertaking from P&I clubs suffice, but in some jurisdictions, an arrest can only be released against a vessel where a bank guarantee, for example, is provided. And then linked to this is the final preliminary point, which is what about the status of the guarantor, the party providing the security? How viable, how financially secure is that entity. And some of you listening today may remember South of England. Many of you may not, and perhaps I'm showing my age. South of England was a P&I club that issued many guarantees, above all in relation to break bulk cargoes into West Africa. And it was a fixed premium club that went bust. And as a result of that, all of the letters of undertaking that South of England provided were effectively unenforceable. So it was a major issue for an awful lot of cargo interests. Okay, so on to the detailed points. Now, as I say, I'll be talking to the letters of undertaking that accompany this presentation. And the first issue there is the identity of the beneficiary. And this goes back wholeheartedly to what Sarah was just talking about in the context of title to sue. So this is the to section at the top of the LOU. And in the cargo-friendly LOU, I fill that out. So it reads, to the cargo owners and or bill of lading holders and their insurers. It's as wide as it possibly could be. And that will encompass any party that will have title to sue. On the other hand, the P&I version I have left blank, and from a club's perspective or carrier's perspective, you would want to be as restrictive as you possibly can. Name specific parties and name as few of them as you possibly can, because it could transpire that the party who is named as the beneficiary does not actually have title to sue. So right from the outset of a claim, that checklist that Sarah was just referring to bears upon the security wording. You need to consider security in the context of all of the issues going to the checklist. Linked to that is the question of what the security should cover by way of the contract of carriage. Now, in the first instance, that will be the bill or bills of lading in question, and they need to be named accurately and fulsomely in the description boxes at the top of the letters of undertaking. But in addition, there could be a claim under a charter party, a voyage charter, and a really common pitfall that we often see amongst the team is where, in fact, the parties to the bill of lading and the charter party are the same, both cargo interest and contractual carrier, with the result that, from an English law perspective, it is very likely that the charter party, not the bill of lading, will be the contract under which the claim can be brought. Therefore, if the claim just secures and just refers to the bill or bills of lading, it won't cover the charter party and it won't be adequate security. So that's a crucial point to consider at the outset. Equally, Sarah was talking about the identity of the carrier. That is very important in a letter of undertaking context. You need to make sure, from a cargo interest perspective, that the carrier against whom the claim will actually be brought is the party against whom this letter of undertaking, or in relation to claims against whom this letter of undertaking will respond. And this is a marked difference between the two letters of undertaking. The P&I Club letter of undertaking simply refers to claims against the owners of the above captioned vessel. It doesn't set out who that entity is. Now, the cargo LOU, on the other hand, does. It says against, and then you insert the name of the registered owners. And then it goes on to say who owned the above named vessel at all material times. And then, crucially, it accounts for an alternative to take account of the possibility of a demise charter. Now, very briefly, a demise charter, often referred to as a bareboat charter, is a charter party under which the charterer, the bareboat charterer, employs the crew. Therefore, where a bill of lading is signed by or for and on behalf of the master, as is very common, the contract of carriage will be with the bareboat charterer, not the registered owner. And so it's crucial to know whether or not there is a demise or bareboat charter. And the cargo interest favourable LOU provides for that with the alternative words against the party who were the demise charterers of the above main vessel at all material times. Now, often P&I clubs will not want to warrant directly that there is or there is not a bareboat or demise charter. Instead, the letter of undertaking will record that they warrant that they are informed by the owners or the bareboat charterers of the position. And in those circumstances, for true belt and braces, it's necessary to have what's called a demise side letter. And that's the third document with you in this talk. And that is simply an additional letter signed by the carrier, the demise charterer, or the registered owner, stating, I am the registered owner, I am the demise charterer, I confirm the position as to the extent or not of any demise charterers. So it puts the issue to bed. And again, this can be absolutely crucial. If the security responds to claims against the wrong party, it is not going to be of any use whatsoever. Onto the level of security, I'll be brief here. The starting point from an English law perspective, and indeed in most jurisdictions, is that cargo interests are entitled to security for their maximum potential claim amount. Now, there's often a bit of haggling about this, depending on the extent of any meaningful threat of an arrest, but the legal position, at least, is quite clear. And the issue often arises whether or not, and the extent to which, that should include interest and costs. And that is a thing of negotiation. The larger the claim, the less relevant interest and costs become in percentage terms. But as a very broad starting point, one would expect interest and costs to be accounted for at around 25 to 35% of the principal claim amount. But it varies. Clubs generally prefer an all-inclusive sum as opposed to an LOU that provides for the principal sum and then plus interest and costs because it is more definitive. I say definitive. In fact, very often LOUs have adjustment mechanisms, and you can see that at clause 4 of the cargo LOU. It allows either party to essentially require an adjustment to the amount of the security provided if, for example, the claim is presented in due course for a greater or smaller amount than the security accounted for at the time. And this, I think, is a really pragmatic provision and benefits both parties. Very often, security is requested and perhaps even an arrest made in circumstances where the full quantum has not yet been concluded. And it behoves both parties, therefore, to put security to one side with the possibility of making suitable adjustments in due course. Right, on to the final 3 points in terms of the detailed elements regarding LOUs. The provision in the cargo-friendly letter of undertaking relating to jurisdiction is at numbered paragraph 3. Now, this version is a London arbitration LOU. In other words, it provides that the claim, the substantive claim, the cargo claim, will be subject to London arbitration. And that is really, really important in circumstances where you then have a provision dealing with service of those documents. And the service issue is critical. We often are provided with cargo claims where the LOU doesn't account for service provisions. In other words, it doesn't state that it will be possible for or service is permitted on either a named entity. Alternatively, the club agrees to nominate London lawyers authorised to accept service within a certain period, such as 14 days. And then we have to serve, if acting for cargo interests, out of the jurisdiction on the owners. And that can be very difficult because sometimes it's just not possible, or not possible quickly and definitively, to get contact details for the owners. So those service provisions and indeed provisions as to law and jurisdiction or arbitration itself are absolutely critical. And it's important to bear in mind there is a distinction between the security wording relating to the jurisdiction for the substantive claim and jurisdiction relating to and law relating to the letter of undertaking itself. Letters of undertaking almost invariably contain clauses setting out what law governs the validity and enforceability of the LOU. It's only those that favour cargo interests that tend to have provisions setting out the law and jurisdiction for the substantive claim. So there is that distinction to be made. And then finally, often letters of undertaking contain express provisions as to their cancellation or return. Now, as an initial point, you would have thought, or at least I certainly would, that is something that favours the P&I club or the carrier. In other words, it is effectively an ability to draw the LOU to a close on a certain event. And indeed, the P&I Club LOU that I provided contains an express 1-year time bar. Now that should firmly be resisted by cargo interests. It's a substantial peril. But beyond that, the LOUs in both instances provide for their cancellation when they are either returned for cancellation to the club that has issued the LOU or upon the conclusion of the claim, whether that's by settlement or via proceedings. In fact, that also benefits cargo interests, and this is not something that is readily appreciated in my experience. And the reason it benefits cargo interests is because if there is something in the security that is not ideal, that actually creates an issue for the cargo claimant, either from a title to sue perspective or in terms of quantum or any other reason that is a real concern, for example, it doesn't refer to the charter party, whatever it is, without that provision, it's not possible to cancel the security and arrest a vessel and seek alternative security. That would be a breach of the terms of the LOU, because its terms specifically state that the LOU is given in consideration, in other words, in exchange for the agreement not to arrest. But if you have a provision stating this contract, the contract evidenced by the letter of undertaking, comes to an end when we return it to you for cancellation, then it ends and you can start again. You're without security, but it gives you the possibility of making that arrest or threatening that arrest to get the preferred security that may or may not be required. Sarah, mitigation and quantum.
Thank you very much, Henry. So dealing first with a quantum issue and looking at sound arrived market value, the quantum of any cargo claim will generally be based upon the difference between the sound arrived market value and the salvage value of the cargo in case of cargo damage. Now, when we talk about the sound arrived market value of cargo, we mean the market value of the goods at the time and place at which they were or should have been delivered. Now, this is the actual place of delivery, i.e. the port, and not any market that the cargo would then have been taken to by road or rail. Now, in reality, there is rarely such a market at the disport location. And even if there is, obtaining evidence of values achieved at the time in question for the specific cargo in question can be very difficult or impossible, and at the very least require expert input. So very often, more often than not, a cargo interest will and should start their claim calculation with 110% of the CIF invoice value. Now, this figure takes into account that any cargo interest will generally be importing goods if there is profit to be made, and of course that there will be ancillary costs which will have been incurred in transporting the cargo to the disport. In reality, of course, the profit margin can be far higher than 10%. And therefore, if you're on the cargo side, it's well worth looking for any other available evidence. 110% of CIF is just a starting point in the absence of any other evidence. And that could be in the form of sale contracts, market indices, or other sales. Now, looking at mitigation, contrary to popular belief, there is no legal duty to mitigate. Instead, the relevant question is whether a cargo claimant acted reasonably to mitigate their loss. It's a question to consider when assessing quantum. And if I want to put that differently, what is commonly called the common law duty to mitigate one's losses is not a duty in the true sense, as there's no positive obligation on the party who suffers a loss, so the cargo interest here, to do anything. It's instead a rule or a doctrine that the innocent party cannot recover any loss which was reasonably avoidable. Now, this is a talk on how to deal with cargo claims practically. So in practical terms, what this means for a carrier facing a claim from a cargo interest is a question of whether the cargo interest took reasonable steps, no more, no less. It is a low threshold. In addition, it's worth noting that the cargo interest can recover the cost of taking those reasonable steps. They can add them to the claim amount. Indeed, to emphasize the low threshold in question, if a cargo interest makes attempts to mitigate that actually make the situation worse, i.e. they increase their loss, provided the steps taken were reasonable, the cargo interest will likely still be able to claim the full amount. By that I mean the loss as increased by their reasonable but perhaps misguided actions. For a carrier to reject a claim or part of a claim on the basis of a failure to mitigate, the burden will be on them to prove, firstly, a failure to take reasonable steps, secondly, that there were specific alternative steps that could have been taken, and thirdly and finally, that those specific alternative steps would have reduced the loss. This would require expert evidence. As a carrier, when a loss occurs, there's a choice as to whether to engage in mitigation steps or not. If you engage, you can potentially lessen the claim amount. By that I mean you might, as a carrier, have contacts or local knowledge that can assist with finding a salvage buyer. But in those circumstances, it would then be harder to argue that the mitigation was not reasonable. It's also a positive in the sense that it can help to solve any practical issues. If damaged cargo remains on board, you can help as a carrier with dealing with that. And certainly in my experience, as a carrier, you're more likely to decrease the claim by engaging than you are by arguing a failure to mitigate. Conversely, if you don't engage with mitigation as a carrier, then the opposite is true. You might have a slightly better chance of arguing that mitigation was unreasonable, but as I said, that is not an easy thing to do. But in those circumstances, you would lose the opportunity to assist cargo in taking steps to reduce the loss, and therefore reduce the claim amount. And also, I suspect a commercial court or tribunal might be quite unsympathetic if a carrier seeks to argue at the 11th hour that a cargo interest should have taken step A or step B in circumstances when the carrier did not tell the cargo interest about that option. Now, as a cargo interest, if you're involved in mitigation, it's absolutely crucial to keep evidence of all of the steps taken. If bids are invited, for example, to purchase distressed cargo, you need to keep evidence of all of those invitations to tender and all of the responses. You would also need to keep evidence of why any particular buyer was chosen. And also, as a cargo interest, it's really important to be prepared to be robust when dealing with any accusations as to a failure to mitigate. It's a very common argument to be put up by a carrier, and it's one that as a cargo interest you should be well prepared to defend. If reasonable steps were taken, then it is likely to be good enough. Now, I'll hand you back to Henry to talk to you about negotiating strategies.
Thanks very much, Sarah. So there will be two elements to this. Firstly, some general negotiating strategy ideas, and then secondly, some particular reflections on costs and interest. I would never have talked about interest a mere three or so years ago, but now interest is higher, the interest rates are higher. It can become, with larger claims, and certainly claims that take quite some time now, if that is the case, it can become a really important element in the claim, as we shall see. The starting point from our perspective in terms of cargo claims is cargo claims will always materialize, as everyone at a P&I club and a cargo insurer knows. It is simply going to be a part of marine insurance and shipping generally. And in that context, there is For our part, a real imperative on dealing with these claims in a straightforward and sensible manner in circumstances where it doesn't behove anyone to try to push unduly hard if, in fact, a sensible deal can be done at the outset. Now, I say sensible, clearly, we are lawyers. Our role is to get the best deal for our clients. And like every lawyer, we will fight hard to do that. But the difference between fighting hard and sensibly, as opposed to hard and unduly aggressively, can be absolutely crucial in the outcome of these matters. And it comes down often to approach, even personality, one might say, alongside legal knowledge and strategy. And there is a cost element here. Everyone, I suspect, listening to us today would appreciate that whilst English proceedings, both court and arbitration, are well regarded in terms of the likelihood of a sensible outcome, they're also very expensive proceedings. And the main reason for that is the sheer detail regarding the evidence. Evidence is looked at with such due regard in circumstances where both witness evidence and expert evidence will be pored over by the court and the tribunal. And so costs become very important, delay proliferates, and it really is important, therefore, to try to strike up a good dialogue with one's opponent, be that lawyer, club, cargo interest, it just doesn't matter, at an early stage, to see if both parties can approach the matter sensibly. Because often there is a common goal of trying to conclude the matter without undue delay and expense. And the best way of achieving that, in our experience, is very straightforward. It is meeting in person if that can be done, alternatively by Teams, beyond that by phone, and not relying too much on written communication. It is very hard to get across a nuanced position in writing. It is much easier to make concessions, for example, and to reinforce the strength of certain points when you are dealing in person with your opponent. And on the subject of concessions, do not make them, as I say here, without a quid pro quo, but do make them. If you have an element to give away, if, for example, the truth of an argument in relation to stevedore damage is that damage ashore, or loss or damage ashore, is not something for which the carrier is going to be responsible, but damage under hook is something for which cargo interests feel owners are responsible under the charter party terms, make that distinction. Take a trenchant position in relation to the good element, give away the weaker element. But that, as I say, is much easier done in person. And the other human element to this is momentum. And here we see a paradigm shift between the effect of momentum, or a lack of it, as between cargo and carrier or club. For a cargo claimant, persistence is as much an important aspect, almost as legal knowledge, which may be a surprising thing to say. But the more there is a delay, the more there is inertia, the more a club or a carrier is able to say, there isn't really any conviction behind this claim, and it really reduces the imperative for a higher settlement. And clubs and carriers often use that to their considerable advantage through some fairly straightforward but very effective techniques. One of which is to always probe the different elements of a cargo claim. The burdens of proof on cargo claims are more pro-cargo than they were 10 years ago, following Volcafe, for example, a case that we've discussed previously and many of you will be familiar with. But nevertheless, there are those initial burdens of proof to show that the cargo was loaded in sound condition at a certain quantity and then lost or damaged during transit. Put cargo interests to proof if you are a carrier, and test title to sue in particular. Make sure those elements are stress tested, and if you are for cargo, make sure you have early answers to that so that you can deal swiftly with the more substantive points. And one of the ways in which carriers and clubs are really able to gain control of the momentum is by prompt answers, holding answers to points that are raised by cargo interests, and then a delayed substantive response. Noted, we will revert on this, and then take your time to respond, because that way you actually have control of the momentum, but you can grind the cargo claim slowly down. And equally, if you are on the cargo side, push for that, and push by phone. Get that personal dialogue going. And behind all of this, I'm talking about negotiating, proposing settlement, engaging in negotiations is never a sign of weakness if done well. For example, the stronger the claim, the more a party should want to engage the opponent in discussing it, because a true discussion would flesh out the true merits of the claim. So do not consider that proposing a proper discussion, a detailed analysis with a view to amicable resolution is a sign of weakness. And I've mentioned in particular mediation there. Now, some of you may not be familiar with mediation. In short, it involves the parties jointly appointing a third party, a mediator, whose role is by way of what we call shuttle diplomacy, to try to assist the parties in reaching a settlement. The mediator does not have any regard for the level of settlement. His or her sole aspiration is for settlement to be achieved. But having a good mediator with real knowledge of shipping disputes assist in the claim is another way of showing real conviction in both the claim itself, or the defence of the claim if you are for the carrier, and a desire to get the matter determined, ideally amicably, as quickly as can be done. So on to costs and interest. The majority of this part of the talk will deal with costs for good reason. The starting point, as many of you will know, is that the successful party in court proceedings in England and in London arbitration is entitled to recover its costs from the other side. So a successful defendant will get its costs from cargo interests, and vice versa if the cargo claimant's claim prevails. Costs, though, can really cause difficulties for the reasons that I alluded to in terms of the complexity of both arbitration and court proceedings in this jurisdiction. Costs can rack up very quickly, and they can become disproportionate to the claim amount, to the extent that the parties are so entrenched and invested in the claim in every sense that settlement is precluded. Hence, the real imperative to look at negotiations early. And one of the best techniques to put pressure on an opponent, above all from the claimant's perspective, to look at settlement is via Part 36 offers. Now, this only applies in practical terms to high court proceedings. You can make what's called a Part 36 equivalent offer in arbitration, but arbitrators have less jurisdiction to order some of the results that the court can enforce and will enforce in certain circumstances under Part 36. Now, it's called Part 36 because it refers to that part of our civil procedure rules, CPR 36, and it sets out various stipulations regarding what we are describing here, Part 36 offers. And the principal point here is there's a real benefit, as I say, to a claimant in making a Part 36 offer, because if it does so and it beats that offer, so for example, a claimant makes an offer to accept $100,000 in satisfaction of a cargo claim, and it is awarded by the court that amount or a greater sum, there are some very adverse cost consequences for the defendant carrier. Firstly, there's an uplift on the principal sum at 10%, up to a maximum of £75,000 uplift. So in that instance, settlement was offered at $100,000. If the court indeed awards that amount to the claimant having made the offer, which wasn't accepted by the defendant can then point the court to the offer, and the court will entitle the claimant to that extra 10% uplift. In addition to which, the claimant can get interest of up to 10% above the base rate on that principal sum, plus costs on an indemnity basis, plus interest on that cost element. Now, the indemnity basis here, what that means is when the English court looks at costs, it doesn't take into account proportionality. In other words, the relationship between the costs incurred and the extent of or amount of the claim, but it will still look at the reasonableness of the costs incurred. But nevertheless, higher costs will be recoverable by the claimant. Really importantly, Part 36 offers can be made before legal proceedings are started, and they can also be made by non-lawyers. You do not need to instruct lawyers like us to make Part 36 offers. And indeed, they can also be made by defendants, albeit they don't have quite as many consequences as I've just outlined as per a claimant's Part 36 offer. But when making a Part 36 offer, there have to be certain specifics observed in the form of the offer, which your lawyers can advise on. But once you know how to navigate through Part 36 and make that offer, then we would always recommend to parties that if they are negotiating and if the proceedings in question are or will be court, then make Part 36 offer at an early stage to really put pressure on your opponents in terms of the adverse consequences of not accepting that offer if matters go against you in the judgment. And then on to interest. Interest used to be, as I say, not that much of a feature, but now we are seeing interest at a much higher level. Interest is governed by the Senior Courts Act, Section 35A, for those that are interested. Effectively, it's 2 to 3% above base rate, which is currently 4.5%. We are seeing commonly interest at 6.5%, sometimes 7%. That's a really material figure in a large claim if it takes a substantial amount of time for the matter to go to judgment. If you're looking at a claim for $1 million and it takes a year of negotiations, then 2 years of proceedings if those negotiations fail, you're looking at over $200,000 just in interest. So it's a very important factor. And in arbitration, the rules are slightly different, but nevertheless, arbitrators have a similar discretion to the court. So that is that for the cost and interest element of negotiations. I hope that is useful and practical. And as a final subject, before we go on to questions, we'll be looking now at circular claims. Now, this perhaps will surprise some of you listening today that this is a material consideration. And I can put it bluntly by saying it either is a very material consideration or it is completely immaterial, depending on the facts. But if it is material, you really need to bear this in mind. And there are 3 types of circular claims up for consideration here. In the first instance, there are indemnity claims via a charter party chain. So consider the following situation. Say you have a rice claim into West Africa to take a very well-travelled path. And the claim concerns the incorporation of charter party terms relating to loading, stowage, discharge, above all, generally stowage and discharge. And the cargo claim is brought under the bill of lading, but that bill incorporates charter party terms, and the charter party is between the owner and the cargo interest. There could actually, and we've seen this a number of times, be an indemnity claim brought by the owner against the charterer, an indemnity to try to cover the liability to cargo interests under the bill of lading, on the basis that if there is a debate as to who is responsible for stowage or discharge, and that's at the heart of the claim, then the cargo claim under the bill can be settled, and then the owners can say, right, we have incurred this loss because we actually believe you, the charterers, under the charter party, the terms of which are incorporated into the bill, which we've settled, but at a lower amount. We believe you're responsible for those operations, so now we seek an indemnity. And that's an immense source of frustration for a cargo interest who has duly, diligently settled their claim under the bill of lading, only to find that they then face an indemnity claim for exactly the same set of facts. So it is really important to be aware of that and to ensure that any settlement will take account of that by knocking on the head the potential for the indemnity claim to be brought via the charter party chain. It should be the case that no such indemnity should arise in circumstances where it's the same terms in the charter party that are being considered in the bill of lading. But often what happens is the bill of lading claim is settled without any determination by court or tribunal as to the effect of those clauses. So then it's still possible for the carrier to bring that indemnity claim. The second scenario is via the interclub agreement. Now, we've talked about this in our previous series on time charters. For those of you not familiar with the interclub agreement, it is essentially a fairly rough and ready agreement to try to apportion liability for cargo claims on a percentage basis. So, for example, where a cargo claim arises due to unseaworthiness, that'll be 100% for owners. Other situations, it'll be 50-50 as between owners and charterers. And in particular, the ICA applies to time charters. And then in other circumstances still, it'll fall 100% for time charterers. So you can have situations in which the cargo claim is settled, but then if there is a series of charter parties, above all time charters, in the chain, whilst the bill of lading claim is settled directly with, for example, the head owner, there is then a trickle-down effect where the head owner seeks compensation under the ICA from the head time charterer, who in turn seeks compensation from the sub-time charterer, etc., depending on how many charter parties there are. And depending on the cause of the cargo claim, a percentage or even all of the liability can be passed down the chain to the charterer. And if the time charterer, the bottom time charterer, happens to be the cargo claimant, which is not a common scenario, but we have seen it happen, then the time charterer can be visited with the very claim that they have brought up the bill of lading chain via a series of interclub agreement claims down the charter party chain. So again, important to consider at the outset what possible circular claims may arise. And the third example is perhaps more complicated, and this relates to Himalaya clauses. I'm conscious that I said at the start we would not be referring to any case law. Himalaya clauses are called that because of a case involving a vessel, the Himalaya, which dealt with these provisions. But effectively, Himalaya clauses seek to achieve the following. They provide that where you have a contract of carriage with a party, if nevertheless the actual carriage is performed by a different party, if cargo interests pursue that different party, A, that different party can rely on the bill of lading terms. B, if it does rely on those terms and cargo interest, if it does rely on those terms, cargo interests are not to bring a claim against that other party. And then C, if it does, and if that leads to that other party then seeking an indemnity under its contract with the bill of lading carrier, and the bill of lading carrier has to indemnify that party, then the cargo interest will in turn have to indemnify the carrier in question. Now that is quite complicated as a set of concepts and words. It is easier to consider in the context of a written clause. And here we have Maersk's standard form bill of lading Himalaya clause at clause 4.2, and I've just cited there two elements of it, which effectively says any subcontractor, and what we're dealing with here, and perhaps this sounds counterintuitive, is if the actual carrier is different from the bill of lading contractual carrier. So the subcontractor here is the owner who is actually carrying the goods. If a claim is brought against that party, well, firstly, under the first provision there, B1, no such claim shall be brought, but if it is in breach of that provision, then to the extent that that actual carrier then brings an indemnity claim against Maersk in this instance, under whatever relationship contract they have between them, and Maersk have to indemnify that party, then Maersk is entitled to seek back under clause 4.2b2 there, is entitled to seek that indemnity back from cargo interests. So the very claim that has been brought by cargo is revisited upon them. So it is important always to consider the effect of Himalaya clauses, and they exist primarily in the context of liner bills. Well, that concludes the prepared talk. We now go on to some questions. Thank you to those of you who have submitted your questions to us. Sarah, can I put one of the questions that we have received to you? It is as follows. Where a bill of lading incorporates charter party terms, but they have conflicting clauses paramount, which will take precedence? And the example that I've been given here is the charter party contains a Hague-Visby clause paramount, and the bill of lading just contains a Hague rules clause paramount. What's the relevance of that potentially, and what do you think the outcome would be?
So I think that's an excellent question, and honestly, I think it's a situation I've never come across, which is perhaps surprising. So yeah, very, very good question, whoever's put this one forward. In terms of the significance of that, so where you have got a bill of lading incorporating a charter party with different terms, whether that's Hague-Visby in one and Hague in the other, whichever way round it is. Obviously, the differences between the Hague and Hague-Visby rules are relatively minor, albeit can have significant impact. Those differences are in relation to the weight and package limitation, and also in relation to Article 3.6 or 3.6 bis, which is relevant to indemnity claims. So if you're dealing with a bulk cargo, bulk rice, sugar, for example, and there's no indemnity provision, it is a distinction with no difference, and therefore not something that you'd need to lose any sleep over. But let's say, for the purpose of the question, that there is a weight or package limitation relevance, which would take precedence. Well, as I said, and I'm buying myself time here, it's not a situation I've ever come across, but I think my instinctive answer is that the terms incorporated into the bill would take precedence over those in the charter party. And I can't remember which way around you proposed it, but I think the reason for that would be one of construction, that the face of the bill states Hague, I think it was in this example, and that would therefore take precedence over the incorporated Hague-Visby via the charter party. But as I say, that's a new one on me and a novel question, but that's my instinctive answer. I can see a couple of questions here about Part 36, Henry, so perhaps I'll put those ones to you. And the first question is, and it's a good one, at what point should a party consider making a Part 36 offer instead of a standard WP offer?
Very short answer to that, at the earliest possible opportunity. I talked at length about the effects of Part 36, albeit only in the context, in practical terms, of court proceedings rather than arbitration. But the short point is that they have that effect whether they are made prior to proceedings or not. And if you're conversant with Part 36, you don't need to be a lawyer in order to make that offer. You just need to do it in a form that satisfies the requirements of Part 36. And once you've done that, on one occasion, then you can do that on numerous other occasions. So the very sooner the better. And Sarah, just very briefly, I entirely agree with you in terms of the clause paramount question. I think without looking at the clauses in question and without knowing whether one states in terms whether it is to prevail over anything to the contrary, I think it would be the provisions in the bill being the operative contract that would prevail over those incorporated in a charter party. But like you, I've never seen an example where the charter party clause provides for Hague-Visby and the bill only provides for Hague. But there's absolutely no reason why that couldn't materialise at some stage.
Thank you, and I should say, please do keep sending questions through on the Q&A box. We'll get to as many of them as we can, and we'll, as Henry said at the outset, pick up any others afterwards. There's another one here, Henry, on part 36, if we continue in that train of thought, which is, how should I alter my approach to a claim following receipt of a part 36 offer?
That is a very, very good question that could take a long time to answer because it depends entirely on the merits, which is an awfully lawyerly answer. But the short point is that because of the pressure that can be exerted via Part 36, if you are on the receiving end of that, so if you are defending a cargo claim, a Part 36 offer is made. If you are concerned that ultimately the claimant may do as well or better than that offer, ultimately in due court. And I'm really thinking about liner claims, for example, where proportionality, they're often smaller claims, containerized cargoes, where proportionality is taken out of the picture in terms of the assessment of costs. We've seen so many examples of claimant lawyers racking up huge costs on very low value claims in the comfort of knowing that they have made a Part 36 offer at the outset, and so proportionality falls away. And it ultimately can be the case that it's in the carrier's interests to settle at a higher level than they otherwise might do in order to avoid the ramifications of a low value claim leading to a high value costs liability. So tread carefully, in short. I have one final question, Sarah. I think we are slightly running out of time, so apologies to all for not being able to get through any further questions, but we will endeavour to do so subsequently. And that is this. You talked, Sarah, about demised charters and vessel owners, as did I in the context of security. The question is simply, where can you find out details as to who owns a vessel and whether there is a demised charter in place?
Yeah, that's a very relevant, very practical question, of which I wish there was a very simple and short answer. Unfortunately, that is not the case. This is something that we, when we're acting for cargo, and our juniors, when we're acting for cargo, can spend a lot of time considering. And the starting point in those investigations is look at what's available online. So Aquasis is a free of charge service where you could register, and that has details of vessel owners on there, and sometimes has details of demised charters. There is also SeaWeb, which is a subscription service, which is a little more detailed than Aquasis and should be more up to date. But, and again, as I say, has details of demised charters in some cases, but neither of those websites can be relied upon as definitive. If they have no reference to a demised charter, that does not mean that there is not a demised charter. It simply means that those who monitor that website are not aware of it. So where does one go next in that situation? Well, generally, one thing I would do would be find out who the club is. That again can be found out via Aquasis or SeaWeb, or simply by going directly to the clubs and looking at their list of entered vessels and contacting the club and asking the question. Registries, say, are not a good place to go really with this. They don't have that information. So the club is likely to be your best chance to get accurate information. And if you get hold of a helpful club, of which there are many, they may well give you a firm answer of no, there is no demised charter, or a yes, and this is the demised charterer. Of course, you may get a slightly less helpful club who will not confirm or deny either way. And in that situation, when you're acting for cargo, you will want to make sure that the point is wrapped up when security is negotiated. What you'll want to do is set up an estoppel. to make clear that if there is a demise charter and the club has not told you about it, that the club is then stopped from saying, aha, got you, cargo interest, you have protected the claim against the wrong entity. So I'm afraid it's not a simple it's a simple question with, I'm afraid, not a very simple answer. But those are the ports of call that I would go to investigate and try to get to the bottom of whether a demise charter is in place. I can see there are other questions, and apologies to say we have run out of time. Henry and I and the team will do our very best to pick up all of those and respond to you individually afterwards. And thank you for those questions. It's great to see the engagement. So really all that is left is for Henry and I to thank you very much for watching and listening to us today, and also for engaging in this entire webinar series. It's been good fun for us, and I hope very useful for you all. So thank you very much.
Thank you. Goodbye.